morning, afternoon, or evening from wherever you're watching or listening. My name is Glick. I'm a lawyer in the great nation of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today's lecture is no exception in terms of extremely important information being provided to you. Normally, I would have a face cam playing, but the majority of this lecture will be me explaining the excerpts appearing on screen. I aim for there to be as few distractions from these excerpts as possible. Let's begin. Arguably the most important aspect of law is denotation. Without a consensus understanding of what words mean, there's no point in having a law because the substance of that law can change, and there's no point to filing a suit because the scope of the suit can change. So, let's clarify a number of very important definitions. Black's Law Dictionary defines a constitution as, quote, the organic and fundamental law of a nation or state, which may be written or unwritten, establishing the character and conception of its government, prescribing the extent and manner of the exercise of sovereign powers. It also defines a compact as an agreement or contract. It also defines contract as an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law, the writing that sets forth such an agreement. Cornell Law School defines a contract as an agreement between parties creating mutual obligations that are enforceable by law. It then also provides qualities of a binding contract, such as mutual assent, consideration, capacity, and legality. Black's Law Dictionary defines an oath as a solemn declaration accompanied by a swearing to God or a revered person or thing, that one's statement is true or that one will be bound to a promise. The person making the oath implicitly invites punishment if the statement is untrue or the promise is broken. The legal effect of an oath is to subject the person to penalties for perjury if the testimony is false. Black's Law Dictionary defines a monopoly as control or advantage obtained by one supplier or producer over the commercial market within a given region. The market condition existing when only one economic entity produces a particular product or provides a particular service. Black's Law Dictionary defines incorporate as to form a legal corporation, to combine with something else, to make the terms of another document part of a document by specific reference. Black's Law Dictionary defines treachery as a deliberate and willful betrayal of trust and confidence. Black's Law Dictionary defines case as a civil or criminal proceeding, action, suit, or controversy at law or in equity. It will become evident very quickly why these definitions are put first and foremost in this expose. My case, Caleb Glick versus American Bar Association, relied on the courts applying true definitions, upholding their oaths, and applying the laws and constitutions as they are written, rather than how their mentor, the ABA, told them to pervert the law. Since we now know the vocabulary we'll be applying in this case, we can verify that those words accurately represent what those same words meant when they were used for forming our current governments, the state constitutions and U.S. Constitution. The founding document of the Union between the states, the U.S. Declaration of Independence, recognizes that any government's just powers is from the consent of the governed, and that when a government becomes destructive, the people have the power to alter or abolish it and to institute new government. This proves government is not eternally sovereign and is formed with the permission of a group of people. That fits all four qualities of a contract. Terms, the powers of the government. Offer, government facilitates the citizens' exercise of their God-given rights. Consideration, if the citizens don't like the government, it can be abolished. And acceptance, the government is instituted for the agreed-to purpose. If you think that's interpretive, consider the founding generation's own words. Thomas Jefferson, author of the U.S. Declaration of Independence, in the Kentucky Resolution of 1798 observes, quote, resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, but that by a compact under the style and title of a Constitution for the United States. In the same document, he refers to the U.S. Constitution as a compact nearly a dozen times. Further, we can consider James Madison's, father of the U.S. Constitution, observations in the Virginia Resolution of 1798, in which he notes, quote, that this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact to which the states are parties, as limited by the plain sense and intention of the instrument constituting the compact. Further, we can consider Thomas Jefferson's opposite, Alexander Hamilton, when he said in Federalist Paper 22, quote, "However gross a heresy it may be to maintain that a party to a compact has a right to revoke that compact, the fabric of American empire ought to rest on the solid basis of the consent of the people. The streams of national power ought to flow immediately from that pure, original fountain of all legitimate authority." Hamilton concedes, though he views it as heresy, that all legitimate governments are formed on the consent of the people. If a compact or constitution is irrevocable, even irrevocable by the people, the government then supersedes the ultimate determiner of legitimate government power. There are many other examples of the founding generation referring to the state constitutions and U.S. Constitution as compacts, contracts, or voluntary agreements between the states, citizens, and general government. It is not a fringe idea, nor a novel one. It is the idea which provides the foundation of the state governments and union government. It is the idea upon which the American Revolution was waged in 1776. Going further, if you can find time to read the works of Algernon Sidney, Montesquieu, Jean-Jacques Rousseau, John Locke, and others, you'll very quickly see how intimately these Enlightenment thinkers influenced the thinking of the founding generation. All of them referred to governments and constitutions as voluntary contracts or social compacts between the governed and the governing. Who is the American Bar Association? Why did I file a breach of contract and unjust enrichment claim against them? First, we need to understand what law was before the ABA decided to get involved. Before 1920, at the latest, aspiring lawyers and attorneys would apprentice under an already practicing attorney or self-study. Once they felt prepared, they would take their state's bar exam and upon passing the exam be sworn in with their court. This may sound unpredictable, but remember, Thomas Jefferson didn't go to law school, nor take a bar exam. James Madison didn't go to law school. Alexander Hamilton didn't go to law school. First SCOTUS Chief Justice John Jay didn't go to law school. George Mason, a delegate at the Philadelphia Convention, didn't go to law school. John Marshall didn't go to law school. Virtually none of the founders had a formal legal education. Yet, they were able to, during a time when accessing reading materials was significantly more difficult than it is today, formulate the government we posture to abide by. If the people who formed our government didn't need, quote, a formal legal education to form the government, why do we need a formal legal education to uphold and prolong it? In fact, it's because a formal legal education has been mandated that the principles held by the founding generation have been perverted and lost. Since 1920, at the latest, the American Bar Association has single-handedly determined who can and can't practice law in 47 of the 50 states. Every state requires their judges and justices to first have practiced law as an attorney. Thus, every lawyer, judge, and justice at the state and U.S. levels for over 100 years have been products of the American Bar Association. How did the ABA do this? It began in 1878 when 75 lawyers met in Saratoga Springs, New York, and formed the American Bar Association. It began as a mandatory, voluntary fraternity of lawyers to share books and case precedents and rules of procedure. Eventually, it grew and its influence expanded. In 1921, it formed its own education committee and imposed its standards on legal education and prospective attorneys. In 1952, the U.S. Department of Education anointed the ABA as the sole accrediting agency for law schools. While the U.S. DOE made into law the ABA's unilateral control on the practice of law in 1952, the ABA had been wielding its influence since 1920, at the latest. In short, the ABA since the 1920s has taught every lawyer, judge, and justice what to think about the law and how to interpret the law. Is this a bad thing? Let's say, for argument's sake, the ABA can legally have a monopoly. What exactly have they been teaching lawyers, judges, and justices? We can look to the standards they publish. In their latest edition, in Chapter 3, titled Program of Legal Education, Standard 303 outlines the curriculum the ABA requires law schools to teach at a minimum. Does Standard 303 require lawyers to study the U.S. Constitution, U.S. law, the state's constitutions, or the state's laws? Does the ABA require teaching the Federalist and Anti-Federalist papers? Does the ABA require teaching the Lincoln-Douglas debate transcripts? It doesn't, even implicitly, mention those crucial documents. It does, however, require lawyers to be educated on, quote, bias, cross-cultural competency, and racism at the start of the student's education and at least one other time before graduation. A jurist's, synonym for lawyer, duty isn't to keep up with specious, insignificant quibbles. A jurist's duty is to know the law and how to apply it to any set of facts so that a victim may receive restitution or an accused may be acquitted. That's it. The ABA, instead of requiring the study of the law like the U.S. Constitution, state constitutions, or any other binding government document, is wasting the time of future jurists with insignificant forms like racism. Let me remind you, every lawyer, judge, and justice has been forcefully indoctrinated with the ABA's curriculum, their future careers used to coerce them into compliance, for over 100 years. The late Justice Antonin Scalia spoke to the ABA's terrible curriculum many, many times during his life. He said the ABA is producing, quote, purposivists, applying the law as it should be written, rather than originalists, applying the law as it is written. This sentiment is echoed by current U.S. Sixth Circuit Judge Emil Thapar. The ABA has been exposed for its blatant political bent for a very long time. You can look to Joel B. Grossman's Lawyers and Judges, the ABA and the Politics of Judicial Selection, which was published in 1965, or former U.S. Congressman Ben Sasse's testimonies on the ABA's clear political bias, or current U.S. Congressman Eric Schmidt's testimony denouncing the ABA. Regardless who you ask, as long as you don't ask a proxy of the ABA is not an honest source of objective legal education. The quickest way I can prove this point to you is in one of the ABA's nominee ratings. SCOTUS nominee Thurgood Marshall once said in 1987, quote, the government they, the founders, devised was defective from the start, requiring several amendments, a civil war, and momentous social transformation to attain the system of constitutional government. When the ABA submitted their review of Thurgood, he received unanimously the, quote, highly acceptable rating, which is the highest approval rating, per se, the ABA gives to nominees. All SCOTUS justices take 2 oaths, or 1 combined oath, to faithfully uphold the U.S. Constitution and all laws made in pursuance thereof. How could someone faithfully uphold a document which they believe to be defective from the start? And why is an accrediting agency highly endorsing that person when his statements are in violation of his oath? The ABA gave Thurgood their highest rating because Thurgood was a perfect example of the ABA's mission. Indoctrinate and output activists in gowns wielding gavels to overthrow the elected and consented to government of the citizens. Mandating licensing in any field doesn't assure us of good quality, it assures us of one quality. That quality, specifically in reference to modern legal education, is woefully deficient, yet enforced nonetheless. Not only is the criminal ABA producing activists in gowns and suits wielding gavels and briefcases, it is making us citizens pay for the ABA's coup d'etat of our government. The ABA receives, quote, tens of millions from the U.S. government. Their revenue in 2021, the last tax document to be publicly accessible, was approximately $130 million. They could be receiving as much as a third, as little as a tenth of their revenue from the dime of the taxpayer. In 2024, I filed a breach of contract and unjust enrichment complaint in a local district court. The district court had jurisdiction in venue considering the matter involved 2 citizens of Texas and the damages surpassed $75,000. I argue the ABA breached the contracts known as the Texas and U.S. Constitutions by way of having a monopoly. Article 1, Section 26 of the Texas Constitution prohibits all monopolies. The Texas Free Enterprise and Antitrust Act of 1983 prohibits all monopolies. The Sherman Antitrust Act and Clayton Acts prohibit all monopolies. Because the ABA violated federal law, presumably constitutional federal law, they violated the Texas and U.S. Constitution. The ABA eventually removed the case to the federal district court, which oversees my region. The ABA argued it is not a citizen of Texas and only a citizen of Illinois. The ABA cited 28 U.S.C. subsection 1332A. What they didn't mention is that same statute, in subsection C1, states, quote, a corporation shall be deemed to be a citizen of every state and foreign state by which it has been incorporated, and of the state or foreign state where it has its principal place of business. The problem that arose was whether the ABA was incorporated with Texas or not. The ABA was immediately faced with a dilemma. Texas law accounts for unincorporated and incorporated corporations' activities. Incorporated entities are granted more lawful activities than unincorporated. The statutes which outline the legal activities of unincorporated entities does not protect the activities of the ABA. In other words, if they're not incorporated, they're conducting illegal business activities, such as accrediting Texas law schools. If they are incorporated, which they are by way of their incorporation on the Texas admission rules, then the case must be remanded. Because the ABA must be a citizen of Texas, otherwise it's conducting a legal business activity, I moved to remand the case. The ABA moved to dismiss the case because my complaint was, quote, frivolous. They argued the ABA doesn't possess a monopoly because I could leave Texas and get a law degree somewhere else. Either knowingly or unwittingly, on the same page, the ABA admits they in fact do possess a monopoly because, quote, the U.S. Department of Education recognizes the ABA as the sole accreditor of law schools in the United States. Further, the ABA argued even if it did have a monopoly, that it is immune to the antitrust laws because the U.S. DOE recognizes it as the sole accreditor. I filed a reply noting the ABA's willful and flagrant admission to possessing an illegal and unconstitutional monopoly. This is important because antitrust laws triple the damages awarded if the defendant is found to flagrantly know it has a monopoly. I also recited the pertinent laws, making certain that monopolies, even, quote, existing under or authorized by the laws of either the United States or of any state, are prohibited. Lastly, I cited a 1995 case, U.S. versus ABA, which was filed by the U.S. against the ABA because the ABA was violating the antitrust laws, the same laws which I cited. This point nullified the ABA's supposed immunity to antitrust laws. Hal R. Ray Jr., a magistrate judge in the U.S. District Court, filed a findings, conclusions, and recommendation. Neither party consented to a magistrate judge intervening and prejudicing the judge. Regardless, he sided with the ABA, arguing, 1. The ABA is not a citizen of Texas, citing 28 U.S.C. 1332. 2. I failed to state a breach of contract because my argument that the U.S. and Texas constitutions are binding contracts between me and the ABA is, quote, groundless and therefore frivolous. Let me remind you, the founding generation stated multiple times that the constitutions are compacts, a perfect synonym for contract. 3. Hal fabricated that I admitted my damages were speculative when they weren't. They were based on conservative estimates backed by salary data from my region provided by the U.S. Bureau of Labor Statistics and the provisions in the Texas and U.S. antitrust laws. 4. Hal believes the constitutions do not provide for private causes of action. Completely baseless because all laws are founded on the principles of the constitutions. When Hal filed his perversions and distortions memo, I realized my case had a new purpose: to expose every judge who prioritizes their prejudicial relationships before their oaths. After finding out Hal graduated from the University of Texas Law School, ABA accredited, I moved for Hal to be disqualified and for sanctions against Hal and the ABA for conspiring to prejudice the court. I cited 28 U.S.C. 455, which requires any judge to recuse themselves upon discovering a conflicting interest. And I posed the question to the court, if the constitutions aren't contracts, what are they? I was never given an answer. Even after being made aware of his prejudicial relationship, Hal refused to recuse himself or rescind his perversions and distortions memo. Despite Hal's clear conflict of interest with the ABA, Hal's admission, along with the ABA's admission of the ABA's unconstitutional conduct, Judge Reed O'Connor, graduate of South Texas College of Law, another ABA-accredited school, accepted Hal's perversions and distortions memo. Reed did assure me that my concerns about Hal's falsifications were, quote, misplaced because the court conducted an independent review of the case. I filed a motion for the court to reconsider. Reed denied the reconsideration. I appealed to the U.S. Fifth Circuit Court, citing the same laws and demanding remand back to state court. The ABA maintained it was not a citizen of Texas, fraud and untrue statement, and that it was immune to antitrust laws. Judges Jolly, graduate of Mississippi Law School, ABA accredited, Jones, graduate of UT, ABA accredited, and Willett, graduate of Duke University, ABA accredited, upheld that the, quote, United States and Texas constitutions do not constitute contracts, and dismissed my case, quote, because Glick's appeal lacks any arguable merit, it is frivolous. I moved to quash the judgment because they ruled that I was obligated to refund the ABA their legal fees. However, 26 U.S.C. 501 prohibits associations like the ABA from receiving any funds that would, quote, inure to any one individual, like an attorney. The Fifth Circuit rejected the motion to quash. On March 2, 2025, I petitioned for writ of certiorari from the U.S. Supreme Court. I used the same arguments and laws, as well as mentioning the appellate judge's clear conflict of interest relationship with the ABA. On May 27th, I received notice the SCOTUS rejected my petition. Rejection means either the SCOTUS upholds the appellate court's ruling or believes the case is meritless. I filed an emergency motion for relief detailing that I am entitled to a hearing if not an explanation. It was never docketed. SCOTUS Justices Clarence Thomas, Samuel Alito, Sonia Sotomayor, and Brett Kavanaugh graduated from Yale. John Roberts, Elena Kagan, Neil Gorsuch, and Ketanji Jackson graduated from Harvard. Amy Barrett graduated from Notre Dame Law School. All of their schools are accredited by the ABA. Considering the federal courts admitted they don't possess authority over citizens by nullifying their authority when they declared the U.S. and Texas constitutions are no longer binding contracts, I filed an original petition for relief in the Texas Supreme Court. The U.S. courts can classify the U.S. Constitution however they wish, but there is only one court on the face of the earth that can determine the classification of the Texas Constitution. That court is the Texas Supreme Court. Let me remind you, every Texas judge and justice swears an oath to, quote, preserve, protect, and defend the Constitution and laws of Texas, and specifically for the judiciary to apply and uphold the Texas Constitution and laws. I tried to file my petition with the Texas Supreme Court 5 or 6 times, but the Texas Supreme Court clerk denied my petition because, quote, the document references a federal case number. The Supreme Court of Texas does not review the decisions of federal courts. I called the clerk's office to explain, as explained in my petition, I am not asking the Texas Supreme Court to review the federal case. I am filing an original petition, which is aptly reflected in the title of my petition. They would argue that I was wrong. I called the judge's chambers and asked what I should do if the clerk is refusing to file my petition. Then I got a call from the Texas Supreme Court clerk, Blake Hawthorne, a graduate of UT, an ABA-accredited law school. He explained that
you are not allowed to contact justices or their staff about your case. And if you continue to do so, we'll have to issue a cease and desist order.
I told him I don't have a case in the Texas Supreme Court. To which he said,
did you understand me? You are not to contact the justices or their staff about your case.
I asked what authority the clerk has in rejecting my petition on the grounds they have, since I'm not asking for review. He said,
that authority has been given to us by the Supreme Court, which has instructed us to do so.
I asked what statute provides him that authority. To which he says,
I don't need to provide you with a statute for that authority. The court hasn't, and we have been authorized and instructed by the court to return or reject filings that shouldn't be filed with the court.
To which I said, based on form. He said,
based on a variety of reasons.
I cited Texas Government Code Title II, Chapter 51.004 for clerks. It does not allow clerks to do what Hawthorne did. To which he said,
Mr. Glick, I'm going to tell you again. The court has instructed us and authorized us, and specifically me, to instruct my staff to return filings.
Then he showed he went outside the scope of the filing. He said,
just like the U.S. Supreme Court, clerk's office has rejected your filings as well.
I told him that's irrelevant and requested the permission slip granting him his extrajudicial powers. He said,
I'm not going to be sending you that. And now you are attempting to harass our staff.
Further,
The rules specifically prohibit you from contacting court staff about your case.
I told him there is no case in the Texas Supreme Court. He told me Rule 9 of the Texas Rules of Appellate Procedure prohibit contact with staff. It doesn't. He said making phone calls is prohibited practice according to Rule 9. It's not. He also claimed the definition of case included unfiled petitions. I asked for any rule which supports his definition of case, at which point he said,
Now you're just being obstreperous. No, you're being obstreperous. You're being vexatious. You're making repeated phone calls to court staff just to harass them because you didn't get your way.
Hawthorne eventually is forced to admit the real reason he rejected my petition. He believes
you're entirely wrong about all of that. Your case has been finally decided by the federal court. It was dismissed with prejudice. It was appealed to the Fifth Circuit. The U.S. Supreme Court denied review. And the decision is final and not reviewable.
He believes even though the federal courts nullified their own authority, their decision is final. In light of Blake's clear abuse of power, I filed a complaint with the Texas Rangers against Blake. Before 7 p.m. of the same day I filed the complaint, a petition for review had been filed on my behalf in the Texas Supreme Court. I immediately moved to correct the docket, citing the very important difference between a petition for review and petition for relief. It was never ruled on. I called the clerk's office nearly every day, demanding they correct the docket, given they were tampering with court records and filing papers on my behalf without my permission. I wrote letters to 2 Texas justices explaining the criminal actions of their clerk's office. No response was given. I filed a petition for writ of mandamus, demanding the court command the clerk to do his job. It was never ruled on. The clerk's manufactured petition for relief filed on my behalf without my permission was docketed on September 5th, 2025. In late September of 2025, the Texas Supreme Court published Miscellaneous Docket 25-9070, which aimed to amend the rules governing admission to the Bar of Texas. To, quote, reduce or end the rules' reliance on the American Bar Association, and that the ABA should, quote, no longer have the final say on whether a law school's graduates are eligible to sit for the Texas bar exam and become licensed to practice law in Texas. While this seems good on its face, the Texas Supreme Court opined it will take up the accrediting power. At the bottom of the document, it approves all the law schools the ABA approved. Further, every justice currently on the bench is a student of the ABA. While they're deleting the ABA's monopoly in theory, the ABA is still very present in substance. After the court publicly recognized the ABA's monopoly, I moved for immediate judgment. It was never ruled on. In early December, the Federal Trade Commission acknowledged the ABA's monopoly and applauded the court's fake effort to eliminate the ABA's monopoly. After this, I filed an emergency motion to expedite ruling in which I argued all questions of fact and law had been answered in my favor and that any further delay would be unjust and suggest a conspiracy between the ABA and court against me. I filed that motion on December 3rd. On December 5th, the Texas Supreme Court rejected the manufactured petition for review filed by Blake on my behalf without my permission. The Texas Constitution forms the State Commission on Judicial Conduct in Article 5. Its duty is to punish any and all judicial officers who enact judicial misconduct. I filed complaints with the Texas Rangers against the 9 justices for conspiring with the ABA, refusing to uphold the Texas Constitution and Texas law, and violating their oaths. Further, I filed complaints against the 9 justices with the State Commission on Judicial Conduct for the same reasons. There has been no contact from the Texas Rangers regarding the matter. In the complaint to the SCJC, I detailed the justices' refusal to reprimand their criminal clerk, their neglect of correspondence, refusal to uphold the Texas Constitution and Texas law, and that they all had a prejudicial relationship with the defendant but refused to recuse themselves, and thus tainting the legitimacy of their ruling in my case. A number of members on the SCJC are judges and attorneys, all of whom are ABA students. The other members are citizens appointed by the Texas governor. Greg Abbott and Ken Paxton are also students of the ABA. Whomever the governor appoints will share Greg's, or in other words, the ABA's beliefs. I called the SCJC a number of times, respectfully requesting updates, findings, whether the justices would be held accountable for their undeniable judicial misconduct. I was dismissed and brushed away each time. Eventually, I demanded the justices be held accountable for their blatant violation and for the SCJC to do its constitutionally enumerated duty. On January 26, 2026, I received notice from the SCJC that the justices will not be held accountable for their blatant treachery because they believe the justices' actions, quote, do not rise to the level of judicial misconduct. The SCJC, who is oath-bound to punish judicial misconduct, believes that a judge/justice who blatantly violates their oath to uphold the Texas Constitution and Texas laws, and who does not recuse themselves when a prejudicial relationship is made known, does not constitute judicial misconduct. According to the SCJC, treachery is not judicial misconduct. I have contacted many legislators and lower tribunal judges. The legislators don't respond, or they prefer the current system because it would be too risky to allow anyone to become a lawyer. Despite what the Texas Constitution states, and despite the free market Texas propagates itself to be, Texas legislators refuse to punish verbatim illegal and unconstitutional, monopolistic, anti-free market behavior. Further, every lower tribunal judge, all ABA students, have either not responded to my email or endorsed the treachery committed by the Texas Supreme Court. When I've contacted law enforcement about issuing warrants of arrest for the conspirators to this illegal and unconstitutional action, again they don't respond, or they endorse the treachery of the Texas Supreme Court. What do we do when our avenues for diplomatic resolve refuse to grant us the resolve we are entitled to by law? We heed the words of the founding generation. For example, Thomas Jefferson said, "One single object will merit the endless gratitude of the society, that of restraining the judges from usurping legislation." Or we can listen to James Madison in the Virginia Resolution of 1798 when he said, "It is there, the states, duty to oppose every infraction of those principles which constitute the only basis of that union, because a faithful observance of them can alone secure its existence and the public happiness. That when the government feels like exercising powers it is not granted, the states and the citizens of those states nullify the actions which are unconstitutional." We must adopt the acknowledgement that was made in the founding document of the Union between the states, quote, "that whenever any form of government becomes destructive, it is the right of the people to alter or to abolish it, and to institute new government, laying its powers in such form as to them shall seem most likely to affect their safety and happiness." We must nullify, quote, "when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government and to provide new guards for their future security." I've been patient. I've shown exclusively good faith in the courts to conduct themselves according to their oaths and the confines provided by the Texas and U.S. constitutions. My good faith is rewarded with neglect, treachery, and conspiracy. Because the courts have shown themselves derelict of their duty, they no longer possess any authority. Do not obey them, their opinions, their agents, or their decrees. Now is the time to decide if we have the will to upkeep our right to self-government, which is bestowed upon us by God and recognized by those who compose the government under which we govern ourselves. Do not comply. Not for my sake, not for fame or fortune, but to prevent making vain the efforts of those in 1776 and 1836. Don't comply, so that we may vindicate what the founding generation uncovered and affirmed in 1776 and 1836. Don't comply, so that the first encroachments can't lead to your last enjoyments. If you want to know what an actual anarchy looks like, it is a government which acts to have laws, but does not participate in the play in any way. In short, don't comply.